I'm Darcel Lobo. I own Dow Law Firm in Normandy Park, and today we're talking about deciding between a will and a revocable living trust. Which one do you want? Which one is better? Let's get into it. So we're first going to start off talking about what a will is and what a revocable living trust is. A will is a document that's really a set of instructions. What do you want to have happen upon your passing? It's a set of instructions, but it does not empower anyone to actually do those things. It has to go through probate. Probate is a court process where the court oversees the administration of your estate pursuant to the terms of your will. So the will gets filed with the court along with some initial documents to open probate. The judge will review it and appoint the person that you've named in your will as your personal representative to be in charge of your estate. When the judge signs this order, you're going to get issued what's called letters testamentary. A lot of times clients come into my office saying, the bank says I need letters testamentary. The title or escrow company says I need letters testamentary for the person's estate. So yes, you get this through probate. Once probate has been opened, the judge signs off on it and the clerk issues letters testamentary that says that you as the executor have the ability to administer the person's estate. So if you're doing a will, it's going to come with probate later down the road. There are some small exceptions here in Washington State. I'm in Washington State, the greater kind of Seattle area. And so with the will option, there will be a probate again, except for those few exceptions. One of them being if you had no real estate and the value of your estate's under $100,000, you should not need a probate. You should be able to use a small estate affidavit. However, otherwise you're looking at probate for your estate. The other option, the revocable living trust, is a living document that you create now. You create this trust now. You are the trustor and the trustee of your trust. You would handle your own assets just as you have beforehand. There's no tax ID number for the trust until after you pass. It all goes through your social. There's no special tax reporting required. But what the trust allows is that you are your own trustee. So you can do whatever you want with your assets, but then you name someone as your successor trustee. Upon your passing, your successor trustee is enabled through the trust to administer your estate according to the terms of your trust. So in your will or in your trust, you're laying out what's going to happen, who's going to receive what. But with the trust, it does not have to go through probate. There's no letters testamentary, okay? The person that you've named as your successor trustee is authorized and enabled to just make the distribution. So liquidate assets, pay any debts that you had, and then make distributions to whoever you have named in your trust. So why would you pick a will? Why would you pick a trust? The will is less expensive to set up. The trust is more expensive, and I have a video, I'll link it below, that explains kind of currently what the prices are for those options here at my office. Again, depending on the complexity of your estate, it could be more. If it's simple, it's going to be, on the lower end of the range, but I do provide that pricing. Also, we do post it on our website, which I'll also make sure is linked below, so you have that information about our pricing. So the will is less expensive to create. The trust is more expensive to create. However, with the will, you're going to have the back end cost of probate. The cost of the will plus the cost of probate in total exceed the cost of the trust. Okay, so at the end of it, the cost of the will and probate are more expensive. However, initially to set up the will is less than the trust. So those are some factors to consider. So let's talk about when clients come to me, some of them have already decided, I know I want a will, I know I want a trust. They may have experiences, maybe someone else in their family or a friend have passed away and they have experience with one or the other. And so they already know when they come to me what they want. If you don't know what you want, I usually give clients a few explanations as to why people would pick a trust over a will or vice versa. So we're going to go through those. So the first one, as I mentioned with the will, is going to go through probate. For some of my clients, they don't want a probate court involved. They don't want a judge involved in their final affairs. So that for them is important enough that they want to do the trust instead. Along those same lines, the will and the probate is all public record. Anyone could go, nowadays, depending on what county you're in, but here in Washington and in King County, it's all available online for anyone to see. So they're going to see what your will said, who received what, and in the probate, it's going to give an accounting of what the assets were, what the debts were, what was left, and what got distributed. For some clients, it's very important that that not be public record. They don't like that being public. They like the trust that gives them privacy because the trust is not filed with the court. It does not go through probate. It is not public record, and they want that for their estate. The third reason is that if my client has real estate in Washington state as well as a different state, I am highly recommending that they do a trust, or else you're looking at probate in each of those states. It's not uncommon for my clients to have a second property, maybe in Arizona or Hawaii or California. And so, maybe they're snowbirds, they go down there for the winters and come back here for the summers. And so if you have second or additional properties outside of Washington state, I'm going to highly recommend that you have the trust, or else you're looking at probate in each of those states where you have those additional properties. And most clients don't want that. Whether you do a will or a revocable living trust, both can be amended or changed or revoked at any point in time in the future. So we're creating this plan now because we want you to have a plan for your estate. But if things change, and they do sometimes, 5 years down the road, 10 years down the road, these are not set in stone forever. You can always come back and make an amendment to it, make some changes later, as long as you have the competency to do so. And so those are kind of some of the reasons why someone would choose a will versus a trust, what the differences are, and a short explanation of how those two different documents work. So if you need help with your estate plan, to create a new estate plan, if you want to talk about a will for yourself or a revocable living trust, give our office a call. We'd be happy to help. Our number is 206-408-8158, or you can visit us online at dowlawfirm.com. Thank you.